Hello everybody, this is Aishley, Verma and intern with LEXIS and Company, and today in this video I will be dealing with a case named State of Haryana versus Ram, Mehra and others. So the citation of the case is Criminal Appeal number 805-806 of 2016, and it was appealed in the Supreme Court of India under Criminal Appellate Jurisdiction. Further, the bench consists of Justice Deepak Mishra, and the date of the judgment is 24th August 2016. Head notes of the case includes section 311, section 313 and section 482 of CRPC and article 21 of the Constitution of India. Facts of the case are as follows. The present case arose from the SLP, that is under 136 article 136, a sailing from the order passed by Honorable Punjab and Haryana High Court. First Additional Judge Gurgaon passed on 16th December 2015, wherein he had rejected the prayer of the accused person seeking recall for the witness under section 311 of CRPC read with section 231 clause 2 of CRPC. The prosecution case before the trial court is that on 18th July 2012, about 7 p.m. the accused person, being armed with door beams and sockets, went upstairs inside M1 room of the Manesar factory of Maruti Suzuki Limited, smashed the glass of the conference room and threw chairs and tabletops towards the management officials, surrounded the conference hall from all the sides and blocked both the staircases and gave threats of going away with the lives of officials present over there. Further, the exoneration continued for quite a length of time. All kinds of attempts were made to burn the alive officials of the management. During the pandemonium, the entire office was set on fire by the accused person, and the efforts of the officials to escape became an exercise in the futility of the accused person had blocked the staircase. The police officials who arrived at the spot to control the situation were assaulted by the workers, and they were obstructed from going upstairs to save the lives of officials. Despite the obstructions, the officials were saved by the police, and the fire was brought under control by the fire brigade. In the incident where chaos was, the sovereign, Mr. Avnish Dev, General Manager, Human Resource of the company, was burnt alive. The said occurrence led to lodging of an FIR, that is FIR number 184 of 2012 at the police station of Manesar. After completion of the investigation, the police filed charge sheet against 148 workers in respect of various offences before the competent court, in which in return committed the matter to the court of session, and during trial the accused person were charged for the offences punishable under section 147, 148, 149, 152, 302, 307, 436, 332, 323, 353, 427, 114, 201, 120B, 34, 325, 381 and 382 of IPC. When the application for bail was filed before the trial court and was rejected up to the High Court, some accused persons moved to this court, that is the Supreme Court of India. The High Court took note of the common ground that the leading counsel of the defence was critically ill during the trial, and due to inadvertence, certain important questions, suggestions with respect to the individual role and allegations against the respective accused person, the injuries sustained by the witnesses, as well as the alleged weapons of the offence used, had not been put out to the said witness. Further, it also took a note of the fact that the senior lawyer had been engaged at the final stage, and such inadvertent errors were discovered by him, and they needed to be rectified in order to take the meaningful defence of a fair trial. The High Court came to hold that a case of recalling had been made out to ensure the grant of the fair opportunities to defend and uphold the concept of fair trial. It further expressed the view that that the when 148 accused persons were facing fair trial together, wherein the prosecution has examined 102, that is 102 witnesses regarding different roles, weapons and injuries attributed to various accused, which is various victims on the day of the occurrence, stretched over a period of time within a huge area of the factory premises, does raise a sustainable interference, and there was a confusion during the conduct of the trial, leading to certain inadvertent omission and putting proper suggestions on material aspect, which are the crucial for the defense in the trial, inter alia, for an offence under section 302 of IPC, that is murder. Further, on the basis of aforesaid reasoning, the High Court allowed the petition and set aside the repugnant order and directed as follows that, in case the learned trial court during the cross-examination of the recalled witnesses is of the opinion that such opportunity is being misused to make the witnesses resign from their earlier testimonies, in that eventually the trial court would be at full liberty to put a stop to that efforts. So these were the facts of the case, and if we talk about the issues, so there were three issues involved in this case. The first issue is whether the reasoning ascribed by the High Court are germane for the exercise of power under section 311 of CRPC. Second issue is whether fairness is acceptable or not in the obtaining of factual matrix. The third issue is should the principle of magnanimity apply. So these were the three issues, and the court finally held the judgment. The judgment are as follows. The honorable court allowed the appeal. The order of the High Courts was set aside. The learned trial court judges was restored to the pass of decision, and the last judgment, that was, they directed the learned trial judge to proceed with the trial in accordance with the law. So this was it. Hope you liked the video. Thank you so much.